This stalwart's journey captures the rhythm of modern Indian advocacy. A balance of precision and restraint, strategy and sincerity. From early years in courtrooms, learning the art of persuasion to steering complex commercial and arbitral disputes, his trajectory mirrors India's own evolution from procedural rigidity to professional credibility. What makes this personality immersive is, of course, his command of arbitration and commercial law, but also the human story beneath it, the setbacks, the sways, the first client who trusted him with the big brief, the choices that shaped his professional discipline, and the quiet conviction that credibility is built case by case, not claimed overnight. We have with us today Senior Advocate Vikram Nankani. So thank you so much for joining us today on Off the Record. I'm in Mumbai today and I'm with Sir Mr. Vikram Nankani, and it is an absolute pleasure. So thank you for your time today, sir.
Thank you for having me.
I really look forward to this conversation with you. And I want to ask you a question which I think everybody who meets a stalwart and established person has in their mind. And they always are a little conscious about asking. And that is, how do you feel now about your success, about your achievement versus what it was like back in the day when you just started out? Is there a difference? Because I want to quote you, you'd said this specifically and I'll read it out. There is always room at the top, and that's true for Mount Everest, and the society is like a pyramid. So from an emotional friendship angle also, have things changed? Have friendships become more transactional, or have they evolved? How have things changed for you? Like, could you reflect on that journey a little bit?
So I must firstly dispel your presumption that there is a stalwart in this room before you. My journey started way back in the mid-80s, and to tell you about that, I've had the privilege of sitting on all sides of the table in this profession. I started as a junior counsel, then I became a partner in a law firm, came out of it to be designated as a senior counsel. And so therefore I have seen all the shades, if you may call it, of this profession. I have not seen, at least I can speak for my colleagues with whom I have worked and interacted, there has not been a significant change in the cultural approach as far as we lawyers are concerned. I think the same camaraderie prevails, and the same kind of understanding is there. It's true that when we started, there were fewer colleagues and fewer professionals at the bar. Now there are many, many more. But I remember an incident that when I first joined the chamber of Mr. Ashoke Desai, the former Solicitor General first and went on to become the Attorney General. When I entered the profession, and he told me this, that look, you can call me either Ashok or you can call me Ashok Bhai, but not Sir. And that example speaks volumes about how colleagues are perceived in this profession. And even today, the age difference between him and me when I first joined him was pretty big. And yet he was so casual about it and so informal about it that he said, I want to be addressed either as Ashok, I'm okay with that, or Ashok Bhai is, Ashok Bhai is a very respected way of addressing a person in Gujarati especially. So that is the kind of warmth that you always see amongst colleagues. We are adversaries in the court, inside, and there we are spokespersons for the client whom we represent, and it's our duty to do our best for the client. But once we are outside the courtroom, I think everything that is said is left behind, and we are back to the coffee table thereafter. And I think that should be the approach that one should have towards all your colleagues in profession. And that has not changed according to me.
That's true. When I was a younger person and I was in the litigation space initially, I was pretty shocked to see this. I was in court assisting one of my seniors, and he was fighting and raging on in the court. And he walks out And he was just so happy and chilling with the opposite counsel in the canteen. And I was like, what is going on? They were like really angry at each other inside the court. I understood that over time. But public perceptions are not like that. So, nowadays courts are live streamed. So people think everybody is everybody's enemy in the court.
You're so damn right that once it so happened, a young colleague, recently when I was a few years back, a young colleague said that, so if I'm talking to you and my client sees me, he's likely to misunderstand. And my jaw dropped. I didn't know how to correct him there and then. But later on, a few days later, when he met me, I said, look, young man, please don't be in awe of such a client. If he believes that, by him seeing you talking to me, he will change his opinion about you, you may as well give up the client. And that is another very important principle that we should learn. At the end of the day, you can't lose the court, you can't lose a judge, you can't lose a colleague, but you can afford to lose a client. A client who has even a speck of doubt in your integrity and in your competence, I think it's not worth having that client. Because there has to be a complete trust between the client and you as his attorney. And if that has got any other qualifications or conditionalities or any things in his mind which are then I think it's important to review that relation with that client. And that's I think something that the youngsters should keep in mind, because today, maybe because of insecurity in the profession, there's so much of competition that people go out of their way to bend backwards to appease the client. I can understand where they are coming from. I'm not saying that they're totally wrong. But at the same time, you can't have a client who sort of controls your personality and your individuality. And you have a corresponding duty not only to the client, but also, as I said, to the court. Sometimes, as an officer of the court and to assist the court, you may have to discharge that duty, which is different from the duty that you have towards the client. And at the same time, you have a certain kind of duty towards your colleagues and peers and your seniors. So I think you'll have to balance all of those relationships very, very carefully.
You specifically pointed out that your senior, your mentor, Mr. Desai, had said that, you call me by my name or with the word bhai. I think there is probably a stark contrast with Delhi here, because that elitism of saying sir is very vibrantly there in Delhi specifically. In Mumbai generally, not only in the legal fraternity, it's less. So if you were to have to reflect on some elitism aspect in the law, would you like to do that?
Well, there is nothing such as right and wrong. At the end of the day, the lawyers are all professionals, also human beings. And I think it is said that in Rome, do as the Romans do. So it's a cultural issue. And I think we have to respect all cultures in this profession. Just because, you say sir to somebody else, it doesn't mean that your own self-respect is given up or compromised in any form or manner. So it's probably a way of addressing a person, or a salutation that you normally adopt as part of your day-to-day interactions with each other.
You also had spoken about how your mentor specifically, I'm going back to that, had said that you need to have a switch on, switch off, or you said that he had a switch on, switch off mode. I really resonated with that, because I think that with all the pressures that life also has to offer, if you don't have that, especially in today's day and age where everything is instant and work life has no boundaries, if somebody can ace that, I think it will be wonderful. So how do you figure that out, the switch on, switch off, if you do it at all?
I don't know whether this is an acquired trait or is it an inborn feature of oneself. But yes, I did see a lot of that in Ashoke Bhai. Just to give you an example, during a course of conference which was happening in a very serious matter, you would find him, hear classical music, Western or Indian. You could, see him digress into some other areas of his interest, and very versatile man. And his areas of interest would be A from astronomy to B for Buddhism to Z for zoology. So, you could talk about anything in the midst of a serious discussion. And sometimes those light moments would help people to, sort of de-stress themselves. Today, the pressures are definitely there because the stakes have become enormous. They are exponentially increased from what it was back in the days, 3 decades ago. The complexities of the transactions are there today. In every matter, it's a high pressure matter that comes to you. And you will have to adapt yourself to keep your balance in that sense. Of course, on a macro level, work-life balance is always desirable because you've got to take care of many things in your life, including your personal life and social life. Work-life balance is very, very essential. How you achieve that, we don't know. Each one has to figure it out for himself. Easier said than done to switch off and switch off. But if you can achieve that, I think I would equate that with success.
That's actually food for thought. Yeah, I would too, because it is quite something which a lot of people are not able to do. And if you're able to do something which a lot of people are not able to do, it definitely equates to something success, success-wise. So but there is also something I want to specifically reflect on now that you talked about high-stake matters. You said that the arbitrations are very high stake now. They are very different from how they used to be, or these transactional matters, commercial matters are very different from how they used to be. They're very monetarily, remuneratively very high stake. How do you maintain composure? What happens inside these courtroom moments or chamber moments or conference moments? How do you maintain that perception or that composure or conviction during such high stakes cases?
So, talking about arbitrations in particular, it is true that India today, the number of arbitrations are on the rise. And yes, it's often spoken about that India should become an arbitration hub. There are many things to be fixed still, but we are on that path of making India an arbitration hub. Having said that, I think what needs to be evolved and where we need to improve are areas where you have preparations at the beginning. Very often what I have seen is, especially in arbitration, and I'm talking of this particular medium of dispute resolution, that the difference between the other Western world, or let's say Singapore, where arbitration has already made a mark for itself, and these are jurisdictions which are today considered to be the top jurisdictions as far as arbitration is concerned. The method or style of working is very different, and we need to learn something from there. Today in India, I find that almost all arbitrations, we sort of prepare along the way. And we start looking at things as the arbitration progresses or matters unfold. So, for example, if you're looking at how do you establish the damages or the quantum of damages, how do you prove what kind of evidence you need to marshal, we don't factor that in at the beginning. And we look at that aspect of the matter when it comes to the point where we now have to put our evidence into the matter, and then we start looking at what documents do we have to prove the quantum, and how do we establish that this is the loss caused to the party concerned. Whereas if we were to do all of this at the beginning, even before you issue the notice of arbitration, then you have a 360-degree view at the beginning. Otherwise, very often what happens is you succeed in proving liability or breach, but you do not succeed in proving damages. And that would be a classic case of operation successful, patient dead. And this, I think, mindset needs to be now incorporated into the practice area, that when you get an arbitration matter, you must look at all the 9 yards of that matter beforehand before you issue the notice of arbitration. You should filter down all the correspondences, important letters, and look at what is the best case that you have before you launch or fire the first salvo. And this is what I have learned and have seen with colleagues across other jurisdictions, that they are so thorough at the very beginning that they know what the end game is going to be. And they know that what are the chances of success today. Because otherwise, typically, a client walks into a law firm today and says, there is a breach of contract by the other side, and we just shoot off a letter and say that contract is terminated without realizing the consequences. So it's important, even from a strategic point of view, that in arbitration particular, and of course what I say for arbitration would also apply to other commercial cases, even suits for that matter, or other forms of company petitions and everything else, that we should, at least on the drawing board when we start off, you should have all the cards on the table as someone who knows what his client wants from the case or from the matter.
Does that apply generally to all cases in your view, or specifically to these commercial cases that you're talking about?
Commercial cases, of course, have their own niche. They fall in a particular slot or silo by themselves. So, of course, it's universal that you would want, in all matters, whether civil or criminal, broadly speaking, to have all preparations done at the beginning. And again, to draw a comparison between other jurisdictions and our country, here, of course, the volume of work is so high. And correspondingly, the fee scale is not as high as it would be in other jurisdictions. But if you look at the work culture there, somebody would focus on one matter at a time, and he will dive deep into this matter and unearth everything from stage 1 to the last stage, and then get involved in it before. And in our country, we are used to handling multiple matters on a day. So given that constraint, that we are here handling number of matters, I mean, you have friends and colleagues who are handling almost sometimes on a given day in a Supreme Court 15-20 matters, and on a final hearing day again multiple. I remember a very interesting incident that I had, and this is thanks to my other godfather and mentor, Anand Bhatt, whom we lost in that tragedy in Mumbai, 26/11. But when I joined Wadia Gandhi, his firm, way back in the mid-80s, he, of course, made me sit in his own cabin, and that was a big discussion that they had internally in the firm, which I got to know much later when I went to him for an interview, and then he said, "Fine, join me from tomorrow." I was surprised, pleasantly of course, to find that he put a table and a chair inside his cabin, and it was a huge cabin, so there was enough space in one corner. He put a table and a chair, and I thought that that was a great honor, because that sort of, you literally are sitting under the same banyan tree as and then learning it there itself firsthand. So he had to go, I think, to Hong Kong for some matter, and at the last moment he could not go, and I was in that sense a rookie. So he said, "Will you go to Hong Kong?" And of course there was a smile on my face. I said, "Of course I'll go." And in those days we didn't need a visa, so one could go overnight. And so I landed up in Hong Kong, and the case was very simple. There was an ex parte injunction granted by the court against an LC. So our clients were the exporters from India, and they were the beneficiaries of the letter of credit. And there was an injunction granted by the Hong Kong court at the instance of the buyer. And then we went there for vacating that injunction. It got vacated in 10 minutes. The judge had come fully ready. He had read the reply. He had read the case papers. First day, of course, it was ex parte, so the injunction was granted by the judge, but the same judge then subsequently vacated it. And I remember we were led by a senior counsel in a QC in Hong Kong. After the matter got over and he came out and he said, young man, what's your plan for the day? And we didn't live in the world where today you have 5 flights a day. So there was only one flight, and I said, well, I have nothing else to do. My flight is tomorrow, and I have nothing else to do. So he said, come with me to the golf club. I was shocked. I said, I would love to, but I don't want to disturb your work schedule, and I hope that you're not doing it just to take me out for lunch or something. So he said, no, I'm done for the day. I took up one matter. I've finished it. I've earned my fees for the day and come. And so I went with him to the golf club. I think it was in Aberdeen, and I was in his golf cart sitting and then we had a good lunch, beer, and he was back to his work in the evening.
Yes.
So as I said, they do have this style of preparing threadbare and go deep into the matter, is because their work culture is different. But there's a lot to learn from that work culture.
Also, a lot of the work has grown in India over the past few years, past few decades, I would say. What you're describing also used to apply in India back in the day. People used to have, they used to close their chambers at 5:36, lawyers, older generation. So, and they used to dig deep into the matter. So the commercial side has grown so much, and all that also takes me to the remunerative side of it. You have spoken recently, I read about how you, said that what you're doing, you should be enjoying that. If you don't enjoy that, then don't do it. But for a lot of people, enjoyment comes when the money comes. That thought process is there. So how do you segregate that thought process? Because that is definitely in a lot of youngsters' minds. They chase commercial litigation, disputes practice, taxation practice, because I don't know if in your view there is remunerative aspect or value to it, versus whether they enjoy it or not. So do you think there should be a segregation there, and how do we really make that segregation?
I think it's again a question of values. But let me go back to the point you made that there were times in India where people would shut shop early and then, have a different life. There is, in fact, an anecdote related to Mr. Jinnah when he was practicing in Bombay High Court. I don't know exactly what the details of that incident, but that anecdote goes to say that a judge volunteered to sit beyond court hours and conclude the matter, and Mr. Jinnah said no, he has no time after 5 o'clock. In those days the court would end at 4:45 or 5. And he said, I'm sorry, even if the court is willing to sit, I'm not inclined to continue with the matter. So I think it's also documented in one of the books on the legal anecdotes too. That kind of, you need that stature to stand up to the judge and say that to the judge. Today, yes, if I was in the same position, I would want the matter to be over, and I would gladly say, all right, I'll keep everything else aside, let me finish it. So there is a difference. But coming back to your question as to, money and the pressure of billing and other aspects, I think it's a issue of value, how ingrained you are into different values, etc. I think everything comes with time. We started in our days internship. It was also called article clerks. I don't know if you are aware of this system of having article clerks. It's prevalent in cities or in states where there is solicitors are one segment of our profession, very important segment of our profession. And when you sign articles to give your exams, solicitor exams, which are conducted by the Incorporated Law Society, we have a lot of them in Mumbai, I can assure you. And it's a very coveted exam that you give, because it covers about 40 odd different subjects, largely commercial and corporate in nature. So you have to sign articles, and when you sign articles, you get articleship or a stipend. And
Yes.
we started with 100 rupees, but it's not the amount. You know, if you work hard, if you work sincerely, your day will come. That 100 would have multiple zeros if you really work up the way to the system. And again, I'm reminded of an incident when I was a partner in a law firm. We were required to travel for a case, and I told the junior member of the team that you travel with me so that on the way we can also have time to discuss. And he came back after some time and said that the client has refused to book me by business class. So I said, but why would you expect that? He said, no, you said we'll travel together. So I was trying to push the client to say that I have to travel with you and therefore it should be by business class. And I had to sit him down and talk to him. And I said, don't worry, that day will come, when without you speaking about it, without you asking about it, it will automatically come. So I think if that is understood in this in today's world by the youngsters, you don't get overnight the kind of. This is, at the end of the day, what is it? It is not about traveling by business class as a matter of ego or prestige. It's a question of respect and recognition. In that sense, if the client today gives you a ticket to travel, you could probably afford it yourself. And I think that's a value system that you have in that you need to get trained into. Again, maybe a little diversion of an example, but just to drive home the point on what value systems mean. There are many, at least I've had the privilege of having been associated with a large number of senior counsels in Bombay with whom I worked with. And I must say that almost all of them, for example, if you would travel with them, and in the evening if you want to have a drink for yourself, many of these senior counsels never charge the client for that. Yes, stay is fine, food is fine, but if somebody wanted to enjoy a drink, he would in fact not only ensure that he buys a drink for the junior colleagues who are with him and would never allow him to pay. That's again a protocol that we very rigidly follow in this city, at least, that it's given when you're at the table with a senior counsel or with a senior colleague or a professional. It is his discretion to foot the bill or buy you a drink. And the same would apply when we would travel with them, which again drives the point that it's more about earning that respect from the client, and instead of being very demanding. And I think if today's young generation understands this magic mantra, they have to just wait for their time, and they will get their credit when it's due.
I think it's called delayed gratification, that value system. It doesn't exist a lot nowadays. People don't even understand the system, I think, of delayed gratification. Younger people, I think it's very important to imbue that in your life, and it really helps people modulate themselves and move forward.
Probably got influenced by the 2-minute food that is made or the instant coffee that is there. So if you are looking for instant gratification, I think that's a short-sightedness.
I agree. And I'll come back to the instant bit from a justice point of view later, but I want to go to the lighter side of things now. You have spoken about how you have experimented initially in your life, in your career when you were young. You were AIR
radio jockey. Yes.
Jockey.
I mean, that was not the word used in those days. You were called as a host or the compare. Now you give them fancy names as radio jockey.
All right. And you said you got swayed with theatre also, but then you realized the court is the real theatre. So let's go back to that. And of course, lecturership is something that you did do in the economic space.
Yes.
So tell us something about that journey, that shift from all of those amazing things that you did and then
Yeah.
law.
So I was in Jai Hind College, and one day I think I was just some of the friends out of fun said, "Why don't you fill up the form for Secretary of the Social and Dramatic Union, and stand for elections, and we'll canvass." And there were some big names who were already dominating the Jai Hind College stage at that time, especially in dramatics. And I've seen the likes of Tiku Talsania, and then Siddharth Randeria, Shafi Namdar, all of them perform on the Jai Hind stage, and they would probably be living there the whole day, rehearsing many. So at one point of time, I got swayed by that form of art and did a lot of theatre in the college days. Virtually was written off to be a lawyer, and then I got an opportunity to conduct the show on Akashvani as we know it.
Yeah.
All India Radio is the English name for it, and they would run a program called Yuva Vani. So I did a few shows for them, and it was basically a show on college campuses. And I was expected to go to different college campuses and get reactions from students on various subjects, current affairs, topics, etc. And then that would be aired. Uh, and then when I finished my graduation, the principal at that time, Principal Kupchandani, called me and he said, we have a vacancy in economics, and since you have majored in economics, because that's a different secret that I had. I wanted in those days, I was aspiring to go to London School of Economics and take up economics on a full-time basis. Law was the second option at that time. But for personal reasons, I couldn't go to LSE. We had some. My father fell sick, and didn't look that economics was the first option at that stage, and then I thought I'll focus on law. But I couldn't say no to Principal Kupchandani. So there I was teaching economics at the Jai Hind College. I taught for almost 2 years. While I was simultaneously doing my law down the road, the same road at the Government Law College. So that was a very fascinating part because I would be a student from 7 to 9:30 at the law school, and 10 o'clock I would be on the other side of the desk teaching economics.
Wonderful. That must be fun, actually. If you look back, anything that you want to share about how the shift happened finally, and you decided that okay, now I want to do law.
So as I said, law came thereafter because I'm the third generation lawyer, and we have the fourth generation also because both my sons are lawyers. So I was a third generation lawyer, and for every son, the father is a role model, and I was inspired by him and his hard work. I mean, he also put in a lot of work and a lot of effort, and I realized the kind of recognition that he is getting, and a lot of features that one looks at as a lawyer with a good personality and a good personal outlook. I think a lot of that I have learned from my father. So I sort of naturally evolved. I don't know when the thought of giving up economics came and when did the law part start, but it came as a natural transition. So I was very happy to do. And then again, in those days itself, I had joined Wadia Gandhi. So it was a full day, morning law school, then my lectures. Yes, that was one of the conditions that I had put, that I will not be able to stay beyond 12 in the college for the lectures. So I was fortunate that they planned my lectures in a way that it would not interfere with my going to Wadia Gandhi for my internship.
Right, right. Another thing from Jai Hind College, I think you attended an alumni meet not very recently, but sometime recently, back in the day. I was reading about you. So I branched upon a particular piece which said that you were speaking at the event, and you said that Mr. Adani, who was a chief guest invited at Jai Hind College, his application was rejected at Jai Hind College, and now he's the chief guest. You said something like that at the event. So, any reflections on that? Any reflections on that journey? Or, of course, I don't intend to prod a lot, but anything that you want to share with the audience, it will be nice.
So, Jai Hind College was in its 75th year, and they asked me to take over as the chairperson of the alumni. So, when your alma mater asks you to do something, you don't think twice about it.
Yes.
You instantly say yes, and that's one way of giving back to the institution from whom you have got so much in life. So I accepted that. And being the 75th year, they were looking at having a series of programs, one of which we thought that we could have Mr. Gautam Adani to come and speak, because his journey is also inspirational. And all the more when we realized that he had applied in late 70s to join Jai Hind College, and for some reason he was not given admission in those days. We thought that life has taken a full circle, and here's a man whose journey would then be fascinating, and it would probably be inspirational even for the young students. So we had him over, and he spoke very well, and the rest is all out there in the public domain.
Amazing. That's a very interesting story, actually. And I'm glad that you shared it also publicly. So thank you for that.
Yes, I had his permission to share it.
Yeah. That's great to hear. That's good to hear.
Yes.
So straight from the horse's mouth then.
Yes, that's right. That's right.
I have some questions in mind with regard to the recent conversations going on around the judiciary, around the legal system. There is a sense of attacking the judges publicly a lot of times. The system itself, sometimes the public attack, sometimes a specific set of lawyers or a specific lobby tends to have an opinion about judges, put out aspersions, cast aspersions on their political affiliation, so as to speak. When things don't go their way, something was not passed in a specific manner, so this judge is, wrong, or she or he is connected to some political party. So that those kind of aspersions start getting cast on judges, instead of actually sitting down and questioning the judgment from a legal lens or criticizing it from a legal lens. So what is your view on that, sir?
I think the fundamental question is, when you as a lawyer appear in court, what is your expectation? Your expectation should only be that you have been given a fair hearing, a fair audience, whereby you have got a full opportunity to put your case forward. And that's that. I mean, I don't want to sound philosophical by quoting the Bhagavad Gita, but that's your job. I mean, you just put it there. You're not concerned with the result. The result will obviously, like in any other part of life, whether it's a game of cricket or anything else, the result has to be in favor of one and not in favor of the other. So the satisfaction that you derive must be limited to the expectation that you have been given a full opportunity to do your best and put forth your case in the manner in which you would desire to be put forth before the court. Once you understand that, then the result will not really matter to you. I mean, as I've said often, again, something that I quote Mr. Desai, I mean, you don't open a bottle of champagne when you win a matter, nor do you go and mourn if you lose a case. You are, in that sense, pretty agnostic or impersonal to the result. Now, if you understand that, then you will not be so critical of what is being said in courts or decided by the courts. And of course, a large part of what is today considered to be fashionable to bash a court or bash a judge on a particular topic is largely because also of the wide coverage that media today has, and the social media, which is again a part of the larger media, which is today penetrated so widely in different classes of the society. Therefore, the awareness also has of all these issues and topics really brought about people to give vent to their feelings, pour out what they think about it, and they do it. Many of them may not be connected with the legal profession. They may be in that sense outsiders looking inside, and they build perceptions just like you would build on any current affairs. But think that it is their birthright to say something on it, and mindless of the fact that they need to draw a line and everybody must work within their boundaries. In favor of the judiciary, what one could say is that they cannot come back and rejoin to what you say in the social media. In that sense, they are a little helpless because you cannot give your own version and start defending yourself and say, no, this is wrong, or this is not what I meant, and so on. So that also one should understand that you are today criticizing someone who, by his very nature of the duty, cannot come back and try and clear the air or justify himself in some form or manner. So when we look at these kind of critical kind of talk which happens in social media or in the mainstream media, we have to keep this in mind that the objectivity should not be you can't get just carried away by one section of the society having after all, it is 6:1, 9 to the other. You see it from your side as 9, I see it as 6. So, but then again, we must draw a line and not go overboard in getting personal or individualistic about the personality which is part of that particular judgment or the case that has been decided. This should be borne in. Now, nobody stops you from coming up with constructive criticism. You criticize the judgment is fine. You may analyze it from a legal standpoint, but to criticize the judge and attribute motives to the judge or attribute certain the thoughts which are not aligned with the norms of the society, I think that is taking it a bit too far, and that is something that we should deprecate.
Yeah, and even though the social media, other media, definitely, I think all sections of the society should practice restraint, but so should judges, in my view. I'm just speaking out loud again. A lot of them get retired and then they speak out on public forums about issues which are social, issues which are religious. When they are sticklers for, discipline themselves when they were in the courtroom. So a lot of judges do that. And I think that also invites criticism from the public, and rightly so. I mean, even if you're disconnected from the legal space and a judge you see who's retired is commenting on a religious issue or on a social issue, then, everybody will have a view as well. So, any view on that?
I think there should be some degree of tolerance also, because as I said, you can't take away the human from the judges.
Yeah.
I would put it in two parts. One is that when you come out of judiciary, you should, by and large, follow the discipline and not criticizing the institution of which you were once a part of. That's one angle. Other than that, there could be views on politics, there could be views on religion, there could be views on many, many other matters of public importance or of the country or even international affairs. I don't think there is such a big taboo or a bar which one could set up to say that a retired judge is to live a life of a hermit or completely isolate himself
Yeah.
from the day-to-day matters. I mean, they, like all of us, would, I'm sure, reading newspapers, watching television, interacting with their family and children, and getting more ideas. So nothing wrong if they have a stand or they take a particular position on a topic or matters of whether of politics in the country or outside. I I don't think that there is anything to be criticized in that sense. Yes, the only exception that I would carve out, and this is my personal view, is that at least don't say anything against the institution of which you were once a part of.
Okay.
That I think is something that it's like you were part of a family. Just because now you're no longer part of that family, you don't hit back at that family so if you keep this, and this is purely personal, that's the view that I have. If you demarcate in this way, I think that's something that should be acceptable.
Yeah, half of the controversies that pick up will get over. I
Yeah.
also think so. All right, sir. I think that was a wonderful conversation with you. I really enjoyed, at least. I know you are very busy, sir, and you took out time for this. So thank you. We're very honored and privileged.
Thank you for having me, and really enjoyed.